All right, my friends, we are gearing up to get started on the program here. We are waiting for the streams to fire up on all cylinders. If you're a regular of the channel, you know I start the show this way every time because we're waiting for the stream to get going. We're on Twitter, we're on Facebook, we're on YouTube, and it looks like we are now live on all of the different platforms. Hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney broadcasting from the beautiful sunny Scottsdale, Arizona. My team and I, we've helped thousands of people over the years facing criminal charges, and in our time in the justice system, we have seen a lot of problems. I'm talking about malfeasance, misconduct, stuff that is happening with police, prosecutors, judges, politicians, anybody in the criminal justice system. We want to hold them accountable, which is why we started this show called Watching the Watchers, where that's exactly what we do. We're watching these different people who are put in place, put in the system to monitor us and hold us accountable and make sure we're following the laws. But who is watching them? Well, that's what we're doing. That's why we started this program. I'm so happy that you're here because we have a lot to talk about today. There is a lot going on in the world. We have something tonight at 6 p.m., which is Arizona time, 9 p.m. Eastern time, which is going to be the presidential debate. And we're not going to try to get too political on this topic, but I do want to go through the records of Joe Biden and Donald Trump as they relate to criminal justice. Criminal justice reform is going to be probably a topic on the list tonight. We saw from Chris Wallace, who's going to be the moderator, that there is indications that they're going to be talking about their records and also talking about racial inequalities and sort of violence in our cities. Those are both topics that they're going to talk about tonight. So we want to review their records. Where do they stand on criminal justice issues? Joe Biden has a long record. Donald Trump has a smaller record, but he does have a record. So we want to see what they're doing. What are they going to be saying? I have a feeling that, all of their records are going to modify slightly as they do with politicians, but we want to sort of look back and say, what have they done? What have they planted in the ground that we can relate back to? But before we get there, we've got some updates we need to talk about. Donald Trump's former campaign advisor, or actually campaign manager, was very responsible for him getting elected in 2016. Just this past couple days ago, I think it was on Monday, he was, or Sunday night on Monday, he was actually arrested and he was sort of confined under this mental health act that takes place in Florida. And of course, we're talking about Brad Parscale, who is all over the news. We've got video, we've got the police report, we've got some reaction. We're going to go through that, and I'm going to give you my thoughts, and then you can come to your own conclusions. We also have updates on Breonna Taylor. We've been covering this case in depth for the past week or two, and there's more information that keeps coming out. Today, there was a grand juror who hired an attorney who filed a motion asking that the entire transcripts, everything that was taking place under the grand jury, be released so that the public can see it. Yesterday, I went on a tirade a little bit, upset at what we were seeing from Daniel Cameron, at least with his statements, and then what we saw publicly released or obtained by Vice.com. We got body camera footage, and the stories are just not adding up. The whole thing is starting to stink, and we're going to cover that. So there's a lot to get through today, and the time is tight. We want to make sure that we finish with enough time to free everybody up to go and watch the debate, because it is going to be a very important one, I think a very good one. So let's get into it. Before we do, if you're not a regular of this channel, do me a favor, hit the subscribe button. We love to have you here. We go live every day at this time. We want to make sure you're part of that conversation. So hit subscribe, hit the notification bell. That will make sure you are notified and you can be here tomorrow and the next day and the next day. All right, so let's get into it. Let's talk about specifically Brad Parscale. This is a story that I want to talk about because, well, it's in the media everywhere. There is some good and some bad and some of the ugly stuff. We see a lot of ugly things that happen in criminal law. People who you think are sort of above board, they're running their lives by the books, they're accomplished, they're highly professional, they get into trouble, they have mental breakdowns, they have troubles in their lives, the police get involved, and it's not good. I mean, it's not good across the board. I don't care whether you're a Democrat or a liberal. We want to make sure that people are cared for, they're treated with humanity, they're treated with respect, and Brad Parscale is going through something right now, something very difficult that I think should be dealt with some humanity. Like I said, it doesn't matter that he's a Republican or a Democrat. He is a person who is hurting and he's in pain, and we want to make sure that he's getting cared for. And it sounds like that's what's happening in Florida. So we want to dive into that a little bit. Now, quick note, a mental health note on this stuff. it's easy. These are the types of cases I don't like to talk about too much because it's, it's a person's innermost sort of, internal struggles that are on display for everybody. But we do want to go through it and have compassion as we analyze the case, because there is some important stuff that we can sort of tease out of this and be useful and add some value to the discussion about what's taking place in our criminal justice system. And so this is the image that is being spread around. This is Brad Parscale. He was outside of his home in Fort Lauderdale in Florida, and he ends up getting just a double leg takedown by this officer. And so the police report that we're going to go through, it provides a little bit more information. You may have seen the video at this point. I am going to play the video here in a quick minute, but we want to start with the police report. And so this was released, I believe, yesterday. I was able to read it today. So this happened on Sunday. This is the police report from the Fort Lauderdale Police Department. You can see here that they're actually naming Brad as the victim on this police report because this is taking place under the Baker-Marchman Act, which in Florida is an act that addresses mental health. So when the police respond to a scene and they see that there is somebody who's going through a mental health crisis, they use this act to sort of take them into custody, make sure that they are delivered the resources that they need to address their mental health problem. So this comes from the police report. He says, on today's date and time, these two officers, we were dispatched to this address in a suicide attempt reported by her husband. Apparently, the wife called and said that he had shot himself. They showed up. They found Candace, which is his wife, sitting in a parked motor vehicle in front of their residence. Candace, which is his wife, told the cops that there was a verbal altercation, said that Brad actually manipulated the gun, loading a bullet into the chamber of his weapon. Candace left, heard a shout, a loud bang afterwards, and presumed that he shot himself. Police showed up. They realized that he didn't actually shoot himself because they heard him sort of pacing around and, ranting, according to this police report. And they heard the dog barking. So they knew he was still alive. And at that point in time, they were, concerned that he may still shoot himself. The wife indicated that there were a number of other firearms, 10 firearms in total within the residence, within Brad's residence. And the cops were concerned about that. So the SWAT team shows up. They have these different units that show up in order to sort of calm the situation down. They don't know what's going on inside. They know he's alive. They're trying to get him out to, coax him out. He says, I'm not going to come out until I talk to my wife. They bring some friends into the mix. Eventually, he does come out. So when we pick up this video in this next clip, he is outside of his residence. And I want you to listen closely because we're going to watch this video and then we're going to go into the other officer's report. So we're going to see right here that the officer who has the body camera on is watching Brad come up to him, and he's not the one who actually ends up tackling him. So another officer comes from a different angle and then, sort of runs and sideswipes him and double leg tackles him. And that officer writes a report. So this report, the first report I just showed you, is from a different officer. Then we're going to read the report from the guy who actually tackled him. So let's take a look at this. And as we're watching this video, I want you to ask yourself, was this enough time for Brad to actually interpret what the officer had to say to him, to sort of process his commands? To me, it seems like he's in a conversation with somebody right in front of him. Somebody else is barking commands at him very rapidly, very quick succession, and then he gets tackled. It seemed to me like it was very, very premature, but I'm curious to see what you think. So let's take a look at the clip. This is Brad Parscale body camera footage. He is in his home and the cops are showing up. He's walking out of his home, and it's about it's not a long clip. Here we go.
Don't. I'm not doing anything. Relax. What happened? So, she started saying all this shit.
Hey, get on the ground, man. Get on the ground. Get on the ground. Get on the ground, man.
Okay. Easy. What are you saying? I didn't do anything. I didn't do anything. I didn't do anything.
Stay down. Put your hands behind your back.
Put your hands behind your back. Hey, we'll figure it all out, all right? Don't worry about it. I didn't do anything.
All right, so let's watch that again because we are going to see.
Okay, you're all right. Relax.
Let's watch that one more time. I want to show how quickly the officer, because we're going to see the officer. The officer is going to justify what he did. He's going to say, I gave him 5 commands. He looked me in the eye and he refused my lawful order. So I want you to, how much time was there? How much time did Brad actually have to react? To me, it looked like he was engaging in a conversation with the officer who had his body camera on. Then another officer starts shouting at him. He kind of looks over there, goes, what? and then boom, he's taken down to the ground. So let's play that one more time just so you can see how quickly it was. Then we're going to read the officer's report where he justifies exactly what he did. So let's take a look. I don't know how to work this thing. All right, let's go now. Apologies. There it goes.
Don't. I'm not doing anything. Relax. What happened? So, she started saying all this shit.
Hey, get on the ground, man. Get on the ground. Get on the ground. Get on the ground, man.
Fuck, easy. Get on the ground. What did I say? I didn't do anything. I didn't do anything.
So very quick. If you actually look at the body camera, you can see the clock. So if you want to go watch that video again, you can see that it's about 3 seconds. It's about get on the ground, man. Get on the ground. Get on the ground. Then he's down. So maybe even less than that. Maybe it's like 1 second. But you can watch the body camera. You can actually count the time. To me, it seemed very quick. Too quickly, you know, and this is what the officer had to say about why he did what he did. So this comes from Sergeant M. Moseri, badge number 1552 on 9/27. From his police report, he says specifically that I was assigned to the immediate action team with other SWAT operators with all these people. We were staged at the north of the target location. Once the police negotiators were able to get him out of the residence, on-scene SWAT commander gave the command for us to move in and physically detain the suspect. I stepped through the wooded area, began to give loud verbal commands to the subject approximately 5 times. Get on the ground. I was dressed in a full police uniform, full police reflective badges and insignia, so on. Subject made eye contact with me, did not comply with any of the commands as I approached him, which again was like a second, maybe 2 seconds. Due to the subject disobeying my lawful commands, coupled with the subject being substantially larger than I am, subject 6'6", wearing shorts with pockets that could easily conceal a firearm. Did that look like it could conceal a firearm to you? I don't think so. I initiated a double leg takedown, lowered my level, wrapped both arms around the subject's lower body while applying forward pressure to his midsection with my forehead. This caused the subject to first sit on the ground, then lie flat on his back. Other officers moved in. The subject, as well as officers, did not appear to have any injuries during this physical interaction. Noted that multiple firearms were recovered, and so on and so forth. So, you know, this is one of those things. Some of the reaction is not so good. You know, people are rightfully drawing comparisons between what happened to this guy and what happens to other people that we regularly cover on this channel. Some people are indicating that, you know, their opinion is that if he were a black person, that he would have been shot, tased, he would have had his neck, you know, a knee laid down on his neck or whatever that is. That's one version of this. This one, you know, these are just a couple things from Twitter that were saying, you know, if he's a black man, he'd be dead. That's the tweet. Oh, and a quick reminder in his own word, you know, so people are sort of having fun with this. They're saying that there's some pretty big distinctions between a white guy and a white cop and a white cop and a black guy. You know, on this channel, I've had a lot of problems sort of boiling everything down to race. I know that has gotten me a lot of criticism on this channel, but to me, this is just a people, you know, versus authority type of dynamic. And a lot of the times, in my opinion, the cops are way too authoritarian. It really doesn't matter what the race is. You know, it could be a black guy, could be a white guy, could be an Asian guy, could be a Hispanic guy. It doesn't really matter. Cops are very aggressive in situations where they don't need to be aggressive. I saw this video and I thought, what did he need to tackle him down for? He came out, he put his beer can on the back bed of the truck. He's having a conversation with the officer and they just took him out. You know, fortunately, right. Yeah. Fortunately, he wasn't shot. He wasn't killed. He didn't get the George Floyd treatment. He didn't get the Breonna Taylor treatment or any of that stuff. But this is a problem. I don't think that people should be treated this way. I don't think that cops, the first instinct should be to just go and level somebody when they're standing there being fully compliant. Then they go back and they write these reports indicating that, you know, well, he could have been concealing a gun. He could have been doing all of these other things. And they justify their actions saying he was bigger than me. I had to tackle him. So the question, I posted this on Twitter yesterday. I was kind of joking about it, but truly, you know, I wanted to know, what's the political orientation of this cop? Is he a Democrat or is he a Republican or is he none of the above? What's his position, right? And I was sort of joking, but kind of not, because a lot of the times we see people are saying that if it's a black defendant or person under investigation or a victim of police brutality and it's a white cop, we automatically jump to racism, right? That's the standard talking point, is these are racist cops who are killing black people. So if this is the situation where a white cop is leveling out a white guy, is that because of a political disorientation because one's a Democrat, one's a Republican. It's jokey, it's facetious, but this is the point. Everybody is looking and grasping for straws to try to tease out other ulterior motives in these types of interactions. They're saying it's racism, or it's political just or weaponizing of the justice system. A lot of problems, when really it's just, in my opinion, a culture of police who are too hungry. They're too just jacked up to go out there and take somebody out. And I have done ride-along. I did a ride-along, not multiple of them, with an officer when I was in law school, and I saw some stuff that was just inappropriate and not okay. And I boiled it down to just a cultural problem in law enforcement. And when we see some of this stuff, that's what it harkens it back to. Now, other reaction across the board, because it's a political figure, and this was one of Donald Trump's sort of right-hand guys in 2016, we are introduced to a new element of uncivil discourse. Normally it's just cops versus people. Now it's cops versus people versus political parties. So the Democrats have taken one side, the Republicans have taken the other, and we saw some of the responses on Twitter. We also see that there are, Donald Trump's campaign actually released a statement about this today. Here's what they said. In a statement issued before the police report was released, Trump campaign manager communications, Tim Murtaugh, said he's a member of the family. We all love him. We're ready to support him and his family any way possible. The disgusting personal attacks from Democrats, disgruntled rhinos, and so on have gone too far. They should be ashamed of themselves for what they've done to their families. Our thoughts are with Brad and his family as we all wait for the facts to emerge. So, I think that's a fine statement. There's been some other stories from the Daily Mail that Brad Parscale was involved in embezzling, $40 million or something like that. And I think we're going to learn a lot more about that. I don't know that that's necessarily relevant to the incident that happened outside of his home. I don't think it is at all, actually. And so, this is something where we see this a lot in criminal law, unfortunately. People have breakdowns. Otherwise law-abiding, otherwise high-performing individuals of both parties, of all races, are doing well in their lives. They have one bad moment, and that can cause them a sort of a criminal catastrophe that will then spiral out of control for the foreseeable future. So I don't know if Brad Parscale has been charged with anything just yet, but we do know that he was taken into custody. Presumably, he's still being held under what Florida calls the Baker Act, and I want to tell you a little bit more about what that looks like. So the Baker Act in Florida, this is from section 394.459. Really, it's all about helping people get treatment for their mental illness, mental problems, right? So a person who's receiving treatment for mental illness shall not be deprived of any constitutional rights. They are to be treated with dignity and respect. It is the policy. They treat them with respect at all times. And then when we go forward, we're going to see that these are some of the rights that Brad Parscale is going to be having. He says that, or the statute says that a person shall not be denied treatment for mental illness or services. It is the policy of the state that the least restrictive, appropriate means available should be utilized to treat the patient, and then that each person who is to be treated in this facility will have a physical examination within 12 hours, and then he'll be authorized by law. So there's all these different things that can happen in Florida, and that's going to be good for Brad Parscale, right? If he's still there, if he hasn't been released yet, then hopefully he is getting some treatment to deal with, what he's going through, because he is right in the middle of a campaign. The stakes are high. Pressure is high. I know he just got demoted from the Trump campaign. He's now being accused of embezzling $40 million. And so he's got a lot of stress going on. And if the investigation justifies those charges, he should be prosecuted criminally and also be dealt with appropriately. In other words, he should be getting the treatment, the mental care, and the care necessary to help him recover from this thing and move on. So enough with that story. We'll continue to poke around and look at it. I'm not sure that he's been charged with a crime or if he will be charged with a crime, so there may not be much to follow there. But just, this is a something that happens, unfortunately, more often than it should in criminal law, and we want to make sure that we're dealing with people in a compassionate way when they go through the justice system. All right, so now let's switch gears a little bit. I want to talk about Breonna Taylor, because we talked about this a lot yesterday, and there's even more that just came out. So we now are knowing that there is a lot of back and forth that's taking place between the Attorney General, Daniel Cameron. We've got some statements from a grand juror who was a part of the grand jury indictment, and we have another statement from Breonna Taylor's attorney. So the attorney who is representing her family as they were going through and getting a settlement with the city for Breonna Taylor's death. If you remember, they settled their case for about $12 million, if I'm not mistaken, a huge settlement. Then we didn't hear much from Benjamin Crump, who is Breonna Taylor's attorney. And now more and more stuff is coming out. Yesterday, we spent a lot of time analyzing and discussing the statement from Daniel Cameron. He came out last week and said, nope, we don't have a lot of evidence. We don't have body camera footage. All this stuff is not available. You know, the grand jury proceedings take place in secret, so I can't talk about it. Well, then some other videos came out. Vice released some videos. We played them yesterday. We do actually have a lot of body camera footage. We have footage from the incident where Kenneth Walker is actually being walked back. He's not even in handcuffs yet, so the warrant hasn't, officially been executed. He's not in custody. So there's a lot of material. We saw Detective Brett Hankinson walking around inside the apartment after he was, fired bullets inside. We know now that he went to the hospital after the fact in violation of policy, in violation of those protocols that require an officer to be with an escort after they're involved in a use of force situation. So, the whole situation just stinks completely. And we were calling that out yesterday. And today it looks like there is some movement on that. So we have a statement from Breonna Taylor's attorney, and he's actually coming out, and he's got a little bit of a fire in his belly now. If you remember last week, I was a little bit, I wouldn't say critical, but I was a little bit, kind of surprised actually at his response to what the grand jury indictment and what that press conference looked like, because I thought he would come out and voice his concern at that point in time. But his statement was very sort of meager last week, and he was indicating that, we all wanted a little bit more out of this thing, but unfortunately that's justice. And it kind of felt like to me like he was just going to move on from this. And then we started to get more material. We started to look at what Daniel Cameron actually said, and more evidence slowly kept coming out. Now the tables have turned a little bit, and this attorney is he's kind of back in the fray, and he's making some good points. So let's take a listen to Breonna Taylor's family lawyer.
Outraged, they were insulted, and they were mostly offended because, like my co-counsels, Sam Agar and Lanita Baker, we're trying to figure out what did the Kentucky Attorney General Daniel Cameron present to the grand jury? Did he present any evidence for Breonna Taylor?
Great question.
And if he did, what was it to get an outcome like this?
Ben, the Attorney General said yesterday, apparently part of the evidence that was presented was this idea of self-defense, that the officers only fired because Breonna Taylor's boyfriend fired first. What do you make of that argument?
Well, Craig, the self-defense argument in Kentucky, as in many states across America, contemplates that you cannot use violence against a third-party innocent bystander.
We covered
like
that here.
Breonna Taylor. And the fact that her boyfriend, Kenny Walker, who has a right to the Second Amendment like any other citizens, even if he's a black man, they thought it was intruders breaking into their home. He thought he was protecting his woman and his castle, and that begs a deeper question, Craig. Why didn't Daniel Cameron present to the grand jury anything about the lie in the probable cause affidavit to get the no-knock warrant that allowed them to be and bust in Breonna Taylor's apartment in the first place?
Yeah, a lot of good questions there. So exactly, we don't know much about the warrant, right? When Daniel Cameron came out during his press conference, he took all of this back and he said, "Hey, we don't even have that part of the investigation under our wing. All of that is actually being done by the feds, by the FBI, and whomever else is involved." So he sort of deferred on that. But yeah, we want to know a lot more about the warrant, right? Because when we talked about the witnesses, we know that the witness that the police are relying on or relied on during their investigation, he changed his story several times. He told them originally he didn't hear an announcement during the knock and announce portion of the warrant execution, but then his story flipped a few months later, and so that's all up in the air. There's a lot of questions about that. The attorney also talks about this idea of self-defense, right? We played the statutes here. We showed them, we clipped them, and we went through them. Under Kentucky law, there is no right to start killing third parties who are not involved when you use self-defense. So self-defense would have been okay used against Kenneth Walker, who, according to the police version of the events, he's the one who fired first and hit John Mattingly. But it doesn't extend, so the officers can fire back at him, but their ability to fire does not protect them against Breonna Taylor. So she got hit with that, and with the bullets from their guns, and they should be subject to some sort of criminal culpability as a result of that. The self-defense envelope doesn't extend to them. He also mentions it, but we covered the statute here as well about the presumption of self-defense. If you remember, when this all took place back in March, the cops arrested Kenneth Walker and they charged him with attempted murder of police officers. Those charges were later thrown out because he had the privilege of self-defense. The cops arguably had it, but he definitely had it. And under Kentucky law, there is a presumption that he's entitled to do that. He's in his home. It's his castle. He has people, who he presumes are breaking in the middle of the night. So he fires his weapon. So he gets to use that protection, not the cops. And we also played a clip on this channel about his attorney. So Kenneth Walker's attorney, who indicated that the whole issue of self-defense is not up to a prosecutor to decide. That stuff should go before a jury, and the jury hears the evidence and then rules on those. In other words, if they would have indicted these officers, all three of them, the case would have proceeded through the criminal court, and they would have explained to the jury, the prosecutors would have come and presented evidence to the juries. The officers' defense attorneys would have come in and presented evidence, and they would have hashed it out and discussed self-defense. And then it's up to the jury to decide, not the grand jury, the jury during a trial. So the police could claim self-defense. It would be their duty to come in and argue it and invoke that, and then the jury would decide. But there isn't that opportunity anymore because there is no case. The grand jury indictment is what starts the case. And if they're not going to indict anybody, then there's not going to be any jury trial. There's not going to be any, more discovery. The case is over. It's closed. So there's nothing we can do about that. Now, there's been a lot of back and forth. It's looking like that the recording of the grand jury will, in fact, be released this week for a couple of different reasons. Number one, Daniel Cameron, the Attorney General, has indicated, well, we have his statement. We're going to get to it. But also there was a proceeding where Detective Hankinson actually went through. He had his arraignment, and the judge indicated that there were going to be some other issues with that as well. So the judge said that, yep, we're putting these grand jurors in an impossible situation because they are subject to a lot of the secret rules that require them to remain silent after they serve on a grand jury. And that puts them in an impossible situation because they saw what Daniel Cameron said in public about what happened as a part of the grand jury investigation, but they were there. They were sitting in there, so they know that his statement doesn't exactly match what happened. So now these grand jurors want to come out and start speaking about it as they should. So there was a lot of back and forth over this stuff. Daniel Cameron said he's not going to release anything originally because he was concerned that this is going to hamper the federal excuses for days. This is going to hamper the federal investigation. This is going to impact the jury pool. If this transcript comes out, the jury's going to see this and it's going to bias their opinions and all this stuff when we just really want to see it. So I've explained previously that typically grand jury proceedings, the transcripts, the record of what happens in those closed door secret proceedings stays secret, but there is a lot coming out now. A lot of people are asking for this to be released, as I think it should. I've been calling for that for a long time. What happened? Remember when somebody asked Daniel Cameron about the makeup of the grand jury? Were there any black people in there or no? And he refused to even answer that question. So we know that Detective Hankinson actually pled not guilty on Monday. So this is the only officer who was formally indicted as a result of the grand jury indictment proceedings. He pled not guilty on Monday. During his plea proceeding, the judge actually ordered that a recording of the grand jury proceedings be entered into the court record. So not only do we have a grand juror who is speaking out, but the judge in Detective Hankinson's case also came out and said, oh yeah, we're going to get a copy of that grand jury transcript for sure, and it's going to go into the record. The petition, well, hang on. So the judge said, it is patently unjust for the jurors to be subjected to the level of accountability the Attorney General campaigned for simply because they received a summons to serve their community at a time that adherence to the summons forced them to be involved in a matter that caused such a palpable divide between the sides. So that's a nice way of saying that, you know, you're demanding that these jurors come in and perform their civic duty, and then when they see something they don't like, you are using the rules of the legal system, of the justice system, of the grand jury, you know, indictment and the proceeding rules there to force them to not say anything. So they witness some problems, but because it's all secret, they can't say anything. So, of course, people are upset about this. And one of the grand jurors filed this motion asking for a few things from the court. So this was filed yesterday on September 28th at 4:18 p.m. And, you know, at the end of the day, we have the grand juror who shall, again, remain anonymous because it's a secret proceeding. They filed this motion in the Jefferson Circuit Court. It's the grand juror versus the Commonwealth of Kentucky. And they're also providing notice to Daniel Cameron, the Attorney General, at this address. Hey, please take notice that we're going to be arguing and hearing this motion on Monday, October 5th. So we're going to add that date to our high profile cases calendar, to our docket, so you can follow along and we can follow along. And we'll have an update on what happens at that proceeding on October 5th when we do the show. So if you're not already subscribed, make sure you do that. Now, what is being said here is basically they're asking for a few things. When we go through the next clip here, you're going to see this is what they're asking for. So we'll explain this, and then we're going to hear from the attorney himself. So the motion for release of the grand jury transcripts, they're asking specifically that the recordings, the reports, all be released. So that's the first part of this motion. So that is what happened when you have a grand jury proceeding or any court proceeding that takes place. All of this stuff these days is being recorded. That means that not in every situation do you have a court reporter who, like you see in the movies, who's sitting there typing away everything you say. Sometimes you have those, sometimes you don't. In this case, they probably did because of the high level of, you know, involvement and media attention and everything. They wanted a very clear record, so they had a court reporter there. Probably also audio recorded, probably video recorded it also. Almost all courtrooms, at least in Arizona, have those capabilities, and that's what it means when things are on the record. So they're asking specifically that the grand jury records be released, and then they're also asking for a declaration of rights. So they're saying that they're asking the honorable court to release all the records in the Breonna Taylor case, and they're asking the court for a declaration of rights pursuant to this statute in Kentucky. They want the court to come out and tell the grand jurors what their rights are. What can they do? What can they say? Because currently at this point in time, they can't say anything. They're bound by certain rules, certain legal rules. And so if this grand juror comes out and starts talking, if he comes out and says, look, I was sitting in there, I saw what Daniel Cameron presented to us. He didn't talk about any charges about Breonna Taylor. He didn't even, talk about self-defense. He came to those conclusions on his own. He didn't present the self-defense arguments to us. He didn't present the presumption of being able to fire a firearm against intruders in your home. He didn't talk about the limitations of the envelope of self-defense extending to protect the officers against their killing of Breonna Taylor. He didn't do any of those things. Or maybe he did. Maybe he did. If he did, I don't know why he didn't release these things just so we could all see them, but he didn't want to release them because I'm going to presume that, the presentation to the grand jury was not as cut and dry, was not as clear as he would like you to believe. And now this stuff is coming out in large part because the judge in Kentucky said, oh yeah, we're going to see this. And a juror who was sitting in there is also upset about this. They watched his public statement. They said, that's not what happened. And so they're coming out and they're wanting to see this stuff made public. Now, again, we're not going to hear from the grand juror until the court comes out and gives us some information about what their rights are. Can this grand juror talk to anybody? Can they not? It's up to the court. What can we do? Our hands are tied because we've been limited within the confines of the grand jury proceeding rules. So hopefully on October 5th, when we have that update from the court, we'll know a little bit more about it. But I do want to play you this clip from the attorney who is representing the juror. His name is Glenn Glogower. Yep, that's it. And he is representing this grand juror, and he's got a statement that he gave today to the media. Let's listen in.
We represent felt compelled to take some sort of an action based upon the indictment that was rendered in the subsequent press conference and messages from the Attorney General's office about how everything played out. At this time, we filed a motion late yesterday to release any recordings, transcripts, reports, etc. of the grand jury. As you all well know, Judge Ann Bailey Smith, in the arraignment for Detective Hankinson, ordered exactly that through the discovery process, and that's something we can discuss. If you all ask the questions, I'll happily address it. But the other part of our motion also was to get a declaration of rights for our client, which would also apply to any other grand juror that was a part of this process. Specifically, we wanted to know from the court system if a grand juror would have the right to speak freely without fear of prosecution, persecution, condemnation, torment, etc., about their experience as a grand juror in this proceeding. Again, our client felt compelled to take action, but before our client can discuss these things freely, they needed to know with the rights and duties as deemed by the court. This is not a situation or...
So it is important that they get this declaration, because if this grand juror comes out and tries to speak, there is very likely, and I'm not licensed in Kentucky, so I can't speak to specifically what their laws and rules are, but in Arizona and California and many other states where I have, some knowledge of this stuff, I'm not licensed in anywhere other than Arizona and California. Let me clear that up. But in other states, there are rules against this stuff. If you have grand jury proceedings, you want to make sure that the integrity of those proceedings are preserved. And if you start disclosing things, the prosecutor's office has some sticks that they can use to beat people into compliance with that, right? They could file they could charge somebody with contempt of court. They could charge somebody with disclosing, some sort of disclosure rules. We have those in Arizona where if you get stuff in confidence from a prosecutor's office and you post it on YouTube on a show like this, you can get in trouble because they don't want you to leak that information out. And that's what this attorney is talking about. He's concerned that the grand jurors have issues, and if they go speak, if they talk to a reporter, if they do something about it, they're going to get in further trouble from Daniel Cameron. So when you read through the rest of that motion, he goes through, and it's a very long motion. I think it's well written, and I think it's highly important that this issue get resolved. I'm not sure that it's going to be that necessary because the judge in the Hankinson case has ordered that be made part of the record. So the grand jury transcript is going to come out. We are going to know more about it, and we're going to have to see what Daniel Cameron says about it. And he did release a statement on Twitter. Reporter Blaine, Blayne, posted this, I think this was yesterday, and this is Daniel Cameron's statement. It says that the grand jury is meant to be a secretive body. It's apparent that the public interest in this case isn't going to allow that to happen. It sounds a little bit bitter to me, right? Hey guys, it's meant to be secretive, but you losers aren't going to let it be secret, so I guess I got to do something about it. As a special prosecutor, our team has an ethical obligation not to release the recording of the grand jury proceedings, and we stand by our belief that such a release could compromise the ongoing federal investigation and could have unintended consequences such as poisoning the jury pool. Despite these concerns, we will comply with the judge's order to release the recording on Wednesday. The release of the recording will also address the legal complaint filed by the anonymous grand juror, and we have no concerns with grand jurors sharing their thoughts on our presentation because we are confident in the case we presented. Then why don't you just release it? You can redact everybody's name. You can just release this one. Once the public listens to the recording, they will see that over the course of 2.5 days, our team presented a thorough and complete case to the grand jury. Our prosecutors presented all of the evidence, even though the evidence supported that Sergeant Mattingly and Detective Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. For that reason, the only charge recommended was wanton endangerment. Wanton endangerment. So that's curious. Thorough and complete case. Our prosecutors presented all evidence. Okay, so we already had that clip. So this is the real question. What happened here? The only charge recommended was wanton endangerment. Are they indicating that the only potential charge that was recommended came from them to the grand jurors? So in other words, did the prosecutors go to the grand jurors and say, hey, based on what we've seen, we're going to give you these facts, and here are the charges that you can pick from. And this one right here is for Detective Hankinson. and it's for wanton endangerment. So do you think the facts apply here to this? And the grand jurors go, sure, we certainly do. And they say, great. So we're going to move forward with that. We presented it. You decided that the law meets the facts, and you indict him. Great. So we're going to seal that one up and move it on. Or are they saying that they presented everything? They went forward and they presented potential murder charges against all three of the cops. And they presented wanton and reckless firing for all three cops, because we know like 50 to 60 bullets were fired all over the place. Was there any other potential criminality that was presented to the grand jury so that they could make a conclusion? What was that? Was it just the one charge against Detective Hankerson, or was it a whole slew of charges that the grand jury got to go and pick from and say, you know what? We listened to the facts, we looked at the law, and we conclude that there's murder here, there's murder there, and there's murder there. Or was it the opposite? We're going to find out. We're going to see this soon enough, because this stuff is going to be released. My understanding is it's going to be released very soon. He said it's going to be released on Wednesday. So we'll follow that along as well. We'll add that one to our high profile case calendar, and we'll let you know what we find out on the next episode. All right. And so the final thing I want to talk about today, and we're going to wrap this show up quickly because we've got a pretty big debate coming up here. And I know most people are not subscribed onto this channel for political commentary, but it's the presidential season, and we do have to talk about some of these things. In particular, because this debate is going to highlight some justice reform issues. We're going to be talking about some criminal law stuff. So let me show you what the debate opening is, or what the debate topics look like. This is from the National Debate Commission, and they're saying that the September 29th debate is going to cover these topics. So specifically, race and violence in our cities, and the Trump and Biden records. And so these are very important to what we talk about on this channel, and I have a lot of questions about these things. I have a lot of questions about both of these gentlemen's records, and I have a lot of questions about what we're seeing going on in our cities, the race and the violence problems, but also the law enforcement and the justice problems. And so are these things going to be addressed? I hope so, and I hope we get some good answers. I'm going to tell you about some of the issues here at the end of this program, about some of the things I would like to hear discussed, or at least talked about or touched upon. But before we do that, let's go through each one of these candidates' records as it relates to criminal justice, because what ends up happening with all politicians, it's Republicans and Democrats, is they like to just sort of modify their record to serve their current political needs. We want to make sure that that doesn't happen. We want to make sure that somebody is held accountable for their record. Despite all the whitewashing, despite trying to cover this stuff up and change the dynamic because the conversation has changed a little bit, let's make sure we pin them down. What were their records? What have they done for criminal justice reform or non-reform? What have they done in this space? And so we want to start with Joe Biden, because he's got sort of a longer record. Let's take a look at what he has done over the years. This is Joe Biden's criminal justice reform record, as pulled from these two websites. And I did some independent research on some of this stuff, so I looked up a lot of these bills and read through them and saw who was the co-sponsors and whatnot. But both of these articles are very nice. All of this information is very nicely summarized in these two articles. One is from Vox.com, one is from Slate.com. And if you're familiar with either of those websites, these are not right-wing conservative websites. These are pretty liberal left-wing organizations, and they were writing these articles back in 2019 and 2015 to sort of dissuade Joe Biden from running. They wanted to, remember, anytime there's a presidential election, you have a primary season where all of the Democrats are running against each other. And so when that happens, people on that side of the aisle, they write articles about the candidates that they don't like that are within their party. So Slate and Vox both write these articles kind of nudging Joe Biden. Hey, maybe your record on criminal justice reform is not so good. Maybe you shouldn't run. So before the ultimate criticism is, I'm a right-wing hack. That's fine. But this is data and information that was compiled and gathered by left-wing organizations. So take that for what it is worth. Now let's go back to it. So Joe Biden has a long record on criminal justice reform, and we're going to dissect each one of these. So in 1972, he was elected to the Senate. 1984, he was what's called an original co-sponsor of a bill. So he was on the Senate Judiciary Committee, and because of that, he's an original co-sponsor of bills. That means they originate and they go through his committee, and he is on board from the beginning. He's pushing the bill forward. So in 1984, he took that tact with the Comprehensive Control Act. So that was in 1984. We're going to dive into what happened with that act. Couple years later, 2 years later, 1986, another Anti-Drug Abuse Act of 1986. Another time he was the original co-sponsor, and according to these articles, he was also a co-author of this bill. Couple years later, they needed to go back and make some amendments to the Anti-Drug Abuse Act in 1988, and so they did that, and we're going to talk more about that. And then in 1994, we have the biggest crime bill that was ever passed in the history of the United States, the 1994 Crime Bill, also known as the Violent Crime Control and Law Enforcement Act. And Joe Biden was the sponsor of this bill, and he was the author of the bill in the Senate. So he's got a long record here of criminal justice reform. He's been highly involved in this for a few decades. And so let's dive into it. What is going on here with Joe Biden's record? Well, the Comprehensive Control Act of 1984 was one of the first things that he actually worked on to get into law. And so here is a breakdown of what we're talking about. What it did is sort of a Comprehensive Control Act, which means it included a bunch of different acts. The Armed Criminal Career Act. And this was something that provided sentence enhancements for felons who commit crimes with firearms if they're convicted of certain crimes 3 or more times. So that's what that was for. So if you're armed and you're a career criminal, you get enhanced sentences. We also have Sentencing Reform Act. And what this did is it increased the consistency in federal sentencing. So it abolished federal parole. It created a commission on the state's sentencing commission, on the United States Sentencing Commission, which is responsible for then articulating the sentencing guidelines that go forward. And so Ronald Reagan ultimately signed this into law, and it was really the first comprehensive revision of criminal law since the early 1900s. So it covered a lot. It was a pretty big act. It increased the federal penalties for cultivation, possession, or transfer of marijuana. It extended the Secret Service jurisdiction so they could cover credit card fraud and computer fraud. It added a new section for hostage taking. And then it had some stipulations about using what's called civil forfeiture to seize assets of organized crime. So you can see that. If you want to actually read the bill, you can go just Google the bill, Comprehensive Control Act of 1984, and you're going to find it'll take you to this link, and you can read the highlights, and you can fact check me on some of that stuff and see whether you agree or disagree. But this was a major bill. Really covered a lot. One of the first bills in a long time that introduced some new stuff into how we process crimes. And so that was really the first major mark that Joe Biden left when he was in the Senate as it relates to criminal justice reform. A few years later, in 1986, he passed another bill or co-sponsored another bill, which was the Anti-Drug Abuse Act of 1986. This one was also signed into law by Ronald Reagan, but Joe Biden was highly involved in it. If you look up this act here, this act, Anti-Drug Abuse Act of 1986, and you look this up, you'll see he was a co-sponsor. This was supposed to be a solution to the recreational drug use, which was to punish the casual user. So remember in the 1980s, we had this really big sort of war on crime going on. Crime was being discussed by both parties. This act came about to punish the casual drug users. We have the mandatory minimum sentences that were imposed on the type and quantity of the drug used, and they increased the penalties for trafficking in synthetic drugs. There were mandatory minimum sentences for drugs which include marijuana. So this is where a lot of those mandatory minimums come into play. And what is a mandatory minimum sentence? It means that if you're charged with a crime that has a statutory minimum, meaning it's set in stone by law that you have to go to jail for a certain period of time. You have to go to jail for a certain period of time. There's no way around it. You can't get less than the minimum. And typically you'll see this in Arizona. We have sort of this kind of 3 categories of offenders. And so if you go into a 3rd category of offense and it's a possession of marijuana charge and you don't have a medical marijuana card and you've got 2 prior drug offenses, you could go to prison from a range of, like 6 to 15 years. And you can't get any less than those 6 years. That's just an example. But the point is, it doesn't matter if you are Mother Teresa, if you're a saint on earth, if you're convicted of a crime under a certain condition, you cannot get any less time than the mandatory minimum. Doesn't matter what you do. You may have changed your whole life. You may have, had a child, bought a home, recovered from drugs, built a business, gotten married, do all of these things. But because of the law, it's written in such a tight, knit fashion that you cannot get less than the minimum, unless, of course, you negotiate something else with the prosecutor or something out with the judge. But the statutory scheme is highly penalized because they didn't want judges to be soft on crime. They didn't want judges to look at the people in front of them and say, yeah, I believe in this person. I think this person can change their life and do something positive in the world. If the judge thinks that, they still have to do the mandatory minimum. They can't do any less than that. So that was something that came out of the 1986 Anti-Drug Abuse Act. And among things they changed, they wanted to change the federal supervised release program from a system that was meant to be a little bit more rehabilitative into a system that's a little bit more punitive. So this is commentary on the bill, but this is stuff that we were reading from some of those articles I referenced, that it was becoming more punitive. So when you think about criminal justice and the different theories of justice, think back to what you read in school, what you read in Sunday school, if you're a religious person, whatever it is, right? There are different ways that people enforce justice, ways different societies, different cultures do it. You had the Hammurabi Code, which was eye for an eye stuff. I think that's what that was. You've got the 10 Commandments with Moses. You've got, the way they do law in different parts of the world. You have this concept of justice being punitive, meaning we're going to punish somebody, versus being rehabilitative. So we're going to help somebody. Somebody's in trouble. We're going to reform them so that they don't commit more crimes versus punish them. And so, there's the many, many different theories of law. You have anarchists who say there should be no laws, and you've got other people who want to criminalize everything and live under, totalitarian dictatorship and things like that. So that's kind of what we're talking about. And this act was sort of the first time, I think, in federal law where we started to see it become more punitive. Tough on crime, a lot of language, both from Democrats and Republicans. Joe Biden was not alone in this conversation. This was a bipartisan thing that was running through the 1980s, and we're going to see more and more and more of it. So this is when our criminal justice system is becoming more punitive. Then we go to the Anti-Drug Abuse Act of 1998. This amends the 1986 Act. So we just had an act in 1986, but that wasn't quite good enough. So this act, the stated purpose, the policy of this thing was to create a drug-free America. And when you go through the act, you'll specifically see that crack cocaine during the 1980s was a problem. And if you recall, crack cocaine, so the way that drugs typically work, or think about it now with our opioid epidemic and, sort of the heroin use problem that we're seeing now. We're sort of in the middle of a heroin epidemic right now. Back in the 1980s, it was a crack cocaine epidemic. And today, what happens is, kids will break their wrist, they'll get into, an injury, or they'll try some of their friends, oxy pills or whatever. They'll get prescribed them from a doctor, and those are very expensive. They cost a lot of money. So what happens is people figure out how to make cheaper versions of drugs that are more powerful. And once they can no longer afford to buy, prescription drugs from their friends, or their doctor stops prescribing them to them, they will then go and find the street drug that is most comparable. So today, that's heroin, right? You go from the high-level pain pills down to heroin, which is a gross, street drug. And the same thing was happening back in the 1980s. Much like today, the heroin epidemic is really impacting a lot of people who are lower level, lower, I would say, social class, the poor, a lot of minority communities, people who grew up in troubled homes. The drug problem, the alcohol problem, the substance abuse problem is typically it's hitting people who are at sort of the most helpless. It's the people who are poor, the people who don't have a lot of assets. They don't have access to the best medical care. They can't go pay $90,000 for a 3-month stay at a cushy recovery rehabilitation center. They don't have access to those things. And so when you start to criminalize that type of behavior, you're really criminalizing the bottom segment of society. You're putting people in prison and in jail who have nowhere else to go. They have nothing else to do. And so we saw that a lot back in 1988. So the crack cocaine had a mandatory minimum penalty for first offense possession. And they were pretty significant. So when we go through, we can take a look. There was a 5-year minimum penalty that applies to possession of more than 3 grams of cocaine base if the defendant has a prior conviction for crack cocaine. So if you have one prior, and you get found with more of it, then you are now going to prison for 5 years. It made possession of more than 5 grams of a mixture or substance punishable by at least 5 years in prison. So this presumably caught up a lot of people who had first offenses, second offenses. They go to prison for 5 years for having a drug problem. 5 years for that. And so that happened in 1988. We also have, as a result of this bill, this allowed the death penalty for anyone murdered during a drug penalty, and then it toughened penalties for drug users. The main kind of goal of this thing, the big goal was creating a drug-free policy and a drug-free America. That was the goal. National Drug Control Policy was that specific organization was created, and then they did a lot of things in terms of increasing the mandatory minimums and making drug crimes more penalized. So they increased that across the board. And this law was also signed into effect by Ronald Reagan on November 18th, 1988. And that was another Joe Biden co-sponsored bill. And then finally, we get back to the sort of the big one, which is the Violent Crime Control and Law Enforcement Act of 1994. So this was Joe Biden's big opus magnus. This was something that he had been working on for a long time. He was the author of this bill in the United States Senate. You can see here he drafted the legislation version in cooperation with the National Association of Police Organizations. So he actually drafted this bill. And I didn't put the link to where we got this information here, but you can find it everywhere. You can find it on Wikipedia. They have a huge article. Vox wrote a big article about this. You can actually go up and look at the actual law itself. It's huge. It's 356 pages. It provided for 100,000 new police officers and $9.7 billion in funding for prisons, and then $6.1 billion in funding for prevention programs. So we have some drug reform, we have drug prevention, but we have a lot more money, basically 30%, 40% more for putting people in prison as a result of hiring 100,000 new officers. So there was a lot there. It expanded the federal, well, hang on a second. Let's see here. It covered sex crimes, immigration law. It covered hate crimes, gang-related crimes, required states to register sex offenders. This law was ultimately signed in by President Bill Clinton. So during this time, if you read back through some of the history, you'll notice that there was a lot of bipartisan support for criminal justice reform throughout the 80s. Then when the Democrats basically took over power, there was Newt Gingrich and there was a lot of the Republicans who were trying to win back power. And one of their aims of attack was to say that the Democrats are soft on crime. It's the same stuff that we're hearing today, right? Tonight on the debate, we're probably going to hear a lot from Trump that Joe Biden is soft on crime and therefore he's not fit to be the president, right? We're going to hear that a lot. Joe Biden, on the other hand, I don't know what he's going to say tonight, but we'll see. We're going to see if he sticks to his record, or we're going to see if he tries to disavow some of that record and sort of come up with some excuses as to why that record isn't applicable anymore. But it is important to note that what the Democrats were doing is they were trying to take this issue away from the Republicans. So they wanted the Republicans to stop calling them babies and being soft on crime. So they took that. They actually took that issue away. Joe Biden drafted the 1994 crime bill, the biggest crime bill in the history of the U.S., and then Bill Clinton signed it into law. And so this was something that we're seeing a lot of the results of all of these 2 decades of work from when Joe got into the Senate in 1970s to the 1994 crime bill. A lot of what we see in our criminal justice system is a direct result, literally, of his work. And we're going to see what he has to say about that tonight. That includes what we're seeing on the streets. That includes, the mass incarceration problem that we're seeing. All of that is a result of some of the work that he has done. I'm not saying he's directly responsible for it, but we just went through his record. He's got 2 decades of working on this stuff. And so now we're seeing the ramifications of that. We also see that as early as 2008, when he was running for president, he supported this. So he supported this pretty clearly. Let me get myself where I need to be there. He said this was, if you go back on the way back archives on his website, you'll see that he actually calls that 1994 crime bill the Biden crime bill. See that right there? He says, in the 1990s, the Biden crime bill added 100,000 cops to the streets. As a result, murder and violent crimes went down. George Bush Bush's cuts to the program have put America at risk and crime rates back on the rise. Joe Biden wants to put 50,000 more cops on the street and add 1,000 more FBI agents to address the rise in crime and the threats of terrorism. So, couple election cycles ago, he was sticking by that. We're going to see, what his record looks like tonight. We're going to see what he has to say about that. But when I was thinking back through this, I was wondering, is there anybody alive today that has had a bigger impact on our current criminal justice system than Joe Biden? And I was trying to think of another person who is alive today who has had a bigger impact on what we see, on a lot of the discomfort, a lot of the problems that people have. Everybody's, protesting in the streets and they're rioting and they want justice reform. They want to defund the police. They want to end mass incarceration. They want to end qualified immunity. They want to defund all this stuff. Who alive today, and I'm curious if anybody, I would love to know what you think about it. Who alive today has had a bigger impact on our current justice system than Joe Biden? And I was trying to think through it. You could make the argument that it was Ronald Reagan, right? You could say he signed a lot of those bills in the 1980s into law, but he was president for 8 years and he didn't sign the 1994 bill. That was Bill Clinton. So Joe Biden's got him beat by several years on that and a bill. You've also got, you could say it was Richard Nixon, because back in the Nixon era, it was a lot of this tough on crime, tough on drug stuff was happening back then as well. Could you make the argument that it was, some attorney general for the federal government? Or is there any other legislator? Is there any other senator? Did Hillary Clinton have a big impact on this criminal justice stuff? I don't think so. Hers was mostly healthcare. Did Obama have anything to do with our current justice system? Not really. I don't remember anything from his years that was too substantial. So most of this stuff goes back to Joe Biden, and it's his record, right? I disagree with a lot of it, but there is his record. Those are the facts about what he brought to our current situation. Now let's change gears, right? If that was Joe Biden's record, let's take a look at what Donald Trump has done while he has been in office. And it's not much, right? Because he's been in office for 3.5 years. And he was elected in 2016. And then the only thing that we have that's really notable is the First Step Act. Donald Trump signed the First Step Act into law. That was in 2018. And that's really kind of been about it from him and from his campaign and from his team. Fortunately, I think the First Step Act is a good first step, but it's not something that, solves all of the problems that we want to see solved around the world and throughout our justice system. But, it is a good first step. Let's take a look at what it does. So it provides inmates with rehabilitative programs and fair sentencing. It provides potential sentencing relief, which reduces the mandatory minimums. It allows some low-risk and elderly inmates to be transferred home to serve out their confinement in their homes if they're at risk, ill. It allows or recommends that inmates are placed within 500 driving miles of their home when possible so that people can go visit them. And it increased credit for good time in prison. So what that means is that if you're in custody and you're on good behavior and you've got good time, you can actually work your sentence down. So it increased that. And there's a calculation that they do when you're in custody, and it basically opened that up a little bit so you get more credit at a faster rate so you can get out of custody earlier. So I think the calculation was if you have 10 years of sentence and you have good time, you could theoretically get out about 1 year and 8 months or 1 year and 9 months early. If all of that time was good, if you actually maximized your good time, then you could get out early. And so that's it. Really, that's it really from Donald Trump. We don't have much more of a record there. We do know that he's had some good conversations with some people in the media. I know that he's pardoned, a lot of people that have been highly respected and highly praised. I think, he had a meeting with Kanye West to talk about it. He also had a meeting with, who's Kanye married to? Whoever he's married to, Kim Kardashian, I think. She was talking to him about this criminal justice reform stuff early in his administration, and she wanted somebody to be pardoned. I think he pardoned her, and because she's done such a great job of helping other people who've been in the system. So some positive stuff on that side of the aisle, which is a little bit unusual because usually the Republicans are very tough on crime and they're pro-police and they want the police to do to be basically immune from any culpability ever. And so the Trump administration has done some things positive. I mean, from my read, that's his record, and you can take it for what it's worth. Now, the second act permits eligible inmates to spend some portion of their final 12 months in a community correctional facility. So the last 12 months, you can be in what's called a community correctional facility. It's known as a halfway house or a residential reentry center. So people can have more of a transition. So when they're coming out of custody, they have a little transitionary period for 1 year before they get reacclimated into society. Sounds like a pretty good idea. They've got some family-based substance programs and so on and so forth. It's a pretty big act. You can go check it out. The Bureau of Prisons actually has some good information on that, a pretty good FAQ. So if you want to look that up, you can. And that's the record for these two candidates tonight. And they're going to be speaking in about 55 minutes from now. And so what are they going to be talking about? There are a few things that I would like to hear from them. Number one is qualified immunity. Are they going to talk about that? We've been, beating about this stuff up on this channel for a long time. What about police unions? Are they going to talk about the unions? The unions are a huge part of the problem. The civilian oversight committees. What about use of force reform? Are we going to be talking about any of those issues? What about things like cash bail or civil forfeiture, which, by the way, was a big part of the 1980 bills, where they were basically saying that if you were involved in a crime, in particular a drug crime, they could just come and seize assets from you. They could just take whatever they want from you. A lot of that is still in effect today. We've got search and seizure, requirements and things about whether those constitutional rights are important to them. Are they going to pass laws to, deal with some of this big tech data stuff, taking up all of our information and gobbling up our information? Are we going to talk about, any of the Edward Snowden revelations about what they're doing, sort of accessing our information without our authority, without a warrant? Any of those issues or those types of issues going to come up? Are they going to talk about COVID-19 and the criminalization we see as a result of these lockdown orders or these mask orders, or any of those issues going to come up today during the debate? We will see. I'm not going to hold my breath, but we will see if Chris Wallace asks anything like that. So because it is such a short time until the debates start, I want to make sure that everybody has time to go and get prepped for this thing. And we're going to end the show right there. So we'll do a chat, we'll do questions and all of that stuff tomorrow. We'll do a post-debate analysis along with all of the other news that we cover on this channel on Watching the Watchers Live. So hit subscribe one more time if you've not already done so. And do me a favor, share the show if you like it. If you like this sort of deep dive analysis, if you think it's entertaining or engaging, or you learn something new, that would be the ultimate compliment if you would just send it to somebody and say, hey, check this channel out. Helps us grow, helps keep the conversation going, and we appreciate it. And then finally, of course, if you know anybody who you know or love, friends, family, anybody who's been charged with a crime in the state of Arizona, we can absolutely help them out. We would love your referral. We have an awesome team here. We got a whole handful of attorneys who love helping people through the criminal justice system so that we can help them help themselves get their lives back on track just a little bit. So that's it for me today. Thank you so much for being here today. Get that popcorn ready because we've got some really important issues to talk about. I will see you tomorrow, 4 p.m. Arizona time, 7 p.m. Eastern time,